Próxima palestra, mas no momento eu fui incumbida, felizmente incumbida de apresentar duas pessoas muito queridas aqui para fazerem suas respectivas apresentações. Now I'm going to switch to English. So it's a pleasure to be here. It's in the Brazilian tradition. I'm going to thank a lot of people before letting others speak. But I swear I'm going to be very both succinct and honest. So thank you so much, Professor Lucas Lima, for the invitation. It's such a joy to be here. Minas Gerais is a wonderful place. I was here many years ago to hear Alain Pelé speak downstairs. So I almost feel like him today. I should have worn a red cape to match the drapes on the table. And it's a special joy to be here, to see Jan speak, who has been so helpful to me during my PhD and my career. And now I'm going to introduce our two panelists. First of all, we have Professor Michele Badin from FGV, Fundação Getúlio Vargas, who is going to be speaking about the remaining roles of the WTO in the geo-economic context. And then she'll be followed by Professor Fabio Morosini, and he's going to be speaking about which future for trade governance insights from the WTO settlement, dispute settlement and beyond. So the idea is I'm going to give them the floor. They both have slides. I think they're going to be relatively brief in their presentations. So I suggest that you come up with some interesting and insightful questions. We've seen many from you already today, which we're very grateful for. So without further ado, Professor Michele Badin, you have the floor.
Thank you, Luisa, for this sweet presentation. So good afternoon to all. It's an immense pleasure to be here at University Federal de Minas Gerais. For me, this is definitely one of the most important hubs on international law in Brazil, providing us with great names, working in the academic board and in practice as well. So sometimes I'm kind of jealous of you, coming from São Paulo. So thank you very much, Lucas, for this invitation. It has been a pleasure to cooperate with you and other professors at the university through the ILA Brazilian branch. Well, my presentation today would be a sort of provocation for those working in the academic community interested in international governmental organizations and the WTO, right, the World Trade Organization, because this is the organization that has been known for being one of the most legalized organizations. But I felt more comfortable after Professor Kleber's alert this morning about this mechanical work that we as international lawyers have before international organizations in thinking about how to reform it and how to refresh the rules and just by a more mechanical work. So I think that this is one of the organizations that has been most challenged in the current days. So here I bring, we can move. First, I would like to start with you, for those that are not so familiar with the WTO functions based on Article 3 of its Marrakesh Agreement that had three main roles: the negotiating function, another one that's monitoring and deliberation, that is the one I'll focus more and I'll explain why, and the dispute settlement that my colleague Fabio will work with you. This organization has been considered like the doorkeeper of the international economic law principles and rules, thinking about most of non-discriminatory rules on trade, but also thinking about not trading goods only, but also trading services, investment, and is mostly based on the idea of the liberal order that was consolidated during the 1990s. Thinking that we would have an increasing engagement of all states in the international economic order based on liberal principles. So, but what is happening is that this notion of geoeconomics is now offering us a new grammar to the international economic law field. bringing ideas of economic statecraft, like states are getting more engaged in their international economics relations, providing money and influence in this order. There is a response on that based on economic security that other countries are thinking this is not really a fair, competitive environment, so then they should take care of their own domestic market. So they are raising concerns on economic security. This also brings this notion of weaponized interdependence that is a result of this increased economic globalization that strengthen the ties of all countries on economic relations, and weaponized trade, that countries are responding with measures based on security on their trade flows, and economic affairs, economic diplomacy. So these are kinds of new words that have been brought to the field. The notion of that comes together with the notion of resilience, of risks. So there is a new vocabulary that is getting part of this international economic relations. So I'll bring the example of how that has affected, in fact, the most recent major meeting at the WTO. And so I call the Geoeconomics at the Ministerial Conference 13 that just happened in Abu Dhabi last February. That had the mandate for mainly 5 topics that would be concerns about the World Trade Organization reforms, thinking about its dispute settlement, the deliberative function, how to think better about the notification and review procedures. 2 other very hot topics on fisheries, trade in fisheries, and the subsidies that countries are used to have for the sector, and agriculture, that has been ever a problem in the whole history of the multilateral trade system. But also thinking about developing countries, the WTO is an organization that resulted from the GATT, that was a general agreement on tariffs and trade right after the Second World War, and just started with 20 countries, 22 countries, and nowadays has more than 170 countries. Most of them, for sure, are developing countries today, and they are requesting attention for their position in the international economic transactions, and thinking about how to have special rules and graduation for their commitments before the organization, and also thinking about how to request the most developed nations to report better on the rules that they are granting to developing countries for better participation in their system. And a 5th topic that is pretty challenging for the organization, because this is a multilateral organization that used to be like based on what we called a single undertaking commitment. That meant that all countries that were part of that organization should be part of all its agreements. But since agreements in many sectors became hard and even harder during the years, to get the consensus of all members, they decided to engage in multilateral negotiations. And the most representative negotiation that we have in that structure is the Plurilateral Investment Facilitation Agreement that I will mention to you. So what happened for countries that went to Abu Dhabi with that agenda, with that mandate to negotiate on those topics, and at a certain level couldn't go ahead with that? In fact, some representatives, diplomatic representatives, said that power politics was in the conference since the beginning. And that was meant to be there because there is what was called as a strategic lack of interest, especially from the US, the United States, that Margaret Hyde, that is a representative of the USTR, was not all the time inside the ministerial meeting, was not really taking due care of the agenda. The European Union that really left part of the agenda to be handled by developing countries, especially for topics that was not really considered to be part of the WTO. It left for India to be leading and to be complaining about the topic. So India was considered the big villain of the ministerial conference at the end. And so this was like a lack of interest of the major powers that led this organization and all its activities in the past more than 30 years, right? Another topic that was at stake was that there were subsidies at many levels. We were not only talking about fisheries and agriculture products. We now have many other topics, the other sectors that have been favored by subsidies in their own countries, and that was not part of the agenda, and that was really very hard for the countries to handle that. And also because of the domestic priorities. Many of the countries didn't want to go ahead in the agenda because of other priorities at the domestic level, and India was pretty clear on that sense for many of the topics. So at the end, what we had was that what was considered to be a good result of this ministerial conference was that we got new memberships. We have increasing number of countries that are interested in becoming part of the organization. There is a decision about supporting the least developed countries, and there is a decision on standards and trade regulation that is like is known as special trade concerns. That is like a follow-up of the measures that countries are taking, considering the different technical standards that they're applying in their trade flows and other specific, more technical regulation that has been closely followed by the committees at the WTO. Another topic that was there, but that was not really a novelty, it was that they decided to have an e-commerce moratorium. That means that countries will not apply any tax to the flow that will come from foreign enterprises that will be participating in this commerce. That will go up to 2026, the beginning of 2026, when it is expected to have the ministerial conference 14, right? And there is an understanding that all the topics about the WTO reform would be by doing. It means that all the committees and council at the WTO will be following up on that, but not really any relevant decision about all the membership, right? So at the end, topics that they could not really work definitely establishing a consensus between the members were about the WTO reform, fisheries subsidies in agriculture, and in annexing the investment facilitation agreement. That I'll comment more on that. So another commentator, that was Robert Wolf, about the ministerial conference, it said that not to cause any harm seemed to be enough to say job done at this WTO ministerial conference. It would say that just let the organization there. Not let's try to change anything because we are living hard moments in the geopolitical side, right? So then countries decided to have the most hot topics limited to what was known as conversations between the delegations that would be dealing with sustainable development, industrial policy, subsidies, policy space, inclusiveness, and it's like all the relevant agenda for today. They just left for conversations because they were even able to have that in the mandate for the negotiation in the ministerial level, right? So what we can see there, I think, thinking about what happened with this ministerial conference, is that the negotiating function is really living a bad time, right? There are even questions if there is a mandate in the WTO agreement that they should hold ministerial meetings each 2 years, and there are people in Geneva saying that we shouldn't do that. it's too risky to think about a next ministerial without results, as we had this one. So the negotiating function is really very heavily affected by the current context that we are living now. So most of the work have been left to the monitoring and deliberation part of the organization. And then we also have topics for the dispute settlement, but I'll leave that for my colleague, Fabio, that will do that with excellency. So I'll mention then two challenging situations for this monitoring and deliberation function at the WTO. The first of it is the case of plurilaterals left to the monitoring. That's the case of the investment facilitation and development agreement. This is normally what happens is that if you want to pursue a plurilateral agreement, it has to be done according to the rules of Article 10.9. That means that requires a consensus of all members that can be a plurilateral agreement. It can happen a plurilateral agreement, right? Since members agreed, part of the membership can negotiate that agreement in a plurilateral form, and that will be part of Annex 4 of the WTO agreement. What happened is that India and South Africa were the countries, and at the end, it seems that it was just India that blocked it and did not give the consensus to have this agreement. Although this agreement has more than 124 participants of the membership, it's about 76% of the membership that is part of this agreement. The reasons for blocking from the side of India was that, in fact, new plurilaterals could, in fact, drive new issues out of the WTO, and they should keep the pressure for having a multilateral agreement instead of a plurilateral one. But this agreement was designed in a way that it would not affect the obligations of those that are not part of the agreement. And even so, for those that are not part of the agreement, they could benefit of the rules that had been negotiated by those that assumed the obligations. But even in that sense, India decided it should not be approved. The fact is that the 120 countries that are part of it decided to sign. Since they are signing it, they will ratify domestically. And at the end, what will happen? Will that be a plurilateral agreement at the WTO or not? It's an agreement that will be challenging the organization and its political importance. And in fact, the investment facilitation agreement is one of the examples that I'm giving you, because there are other agreements that are online waiting for this sort of negotiation and to be part of Annex 4 of the agreement, right? The second challenge that I would like to bring you for this monitoring function of the WTO, because now for this investment facilitation agreement, there is a question, should the Committee on Facilitation keep the track of it, and what will happen with it? And what countries say is like, let's wait and see what will happen, if countries will sign or not, and then the committee will decide what will happen and try to convince India maybe and next ministerial to have the consensus for that. The second challenge that I brought is about the continuous violation of the WTO basic rules on non-discrimination. That would be national treatment, most favored nations, markets access rules to be the same for all members of the organization, and protection of against unfair trade practices, and keeping the competition of and wealth of the world economic system. The thing is that there are many measures that have been taken based on national security justifications. And security is going beyond defense, and Article 21st interpretations that probably Professor Fabio will mention a little bit on that. I just brought to you an example of the the words of Article 21 about what would be security exceptions, and it's very clear that we'll be dealing with essential security interests and cases related to defense, arms, and war. But countries are taking the interpretation from this article to get its exceptions and to raise protectionist measures for different sectors in their economies, but especially sectors that are considered very strategic in the current technological moment and development, right? And this is the Article 21 that has been negotiated in the 40s. What we see is that there are similar norms that have been replicated in trade agreements, bilateral, plurilateral ones, regional ones, and investment agreements. They kind of replicate this one. But what has been happening is that countries are amending this article in a way that, especially India, are crafting this article in a sense that no one should interpret this article except for the country that is applying. This is for the sovereignty of each country to say what is its security measure and its national needs. So it's kind of taking this out of dispute settlement mechanisms that has been established in International Economic Forum. So what we see is that WTO has been pretty challenged in this geoeconomic context. The liberal rationale has gradually been replaced by what has been named as managed interdependence. And if we think about the way that WTO was qualified in the 90s when it was just created, it was like it was replacing trade politicization by trade legalization. And what we see now is that geoeconomics is calling for a repoliticization, but not only repoliticization, but a relegalization, because there are new norms that are coming from that. Not only national norms, but also international norms that are coming with this new geopolitical and geoeconomic context. And if we think about the WTO functions, there is a fundamental question that is about, should we keep the ministerial conferences for negotiating function? A second question is, what does it mean to monitor the policies based on the lack of reciprocity and discrimination? Because we are at the multilateral level. It's just for transparency means. And for the dispute settlement, we have many other remaining questions that probably Professor Fabio will help us to answer it. So I'll be glad to talk more about this topic with you. This is just a taste of what is going on. Thank you.
Brilliant. Thank you so much. That was very interesting and also left a lot of cues that I'm hopeful that Professor Morosini will be able to fill now for us. So you have the floor, Fabio.
Okay, can you all hear me? Well, I don't know how to. Maybe I should do this. Okay. So I'll start the Brazilian way, and I'll thank everyone here. Please, each one of you. No, I'm just kidding. I'm so happy to be here today, to be among friends. I couldn't be happier in this table because I have two co-authors. People that I work with for many, many years in different capacities. And I'm very happy to be here at UFMG, which is this great law school. And I thank Professor Lucas Lima for the invitation. I'm also very happy to see Professor Galindo in the audience and to learn from him this morning, and to see also and to meet Professor Klabers. You all know that I'm critical of textbooks, but I do like yours. When Lucas invited me to participate in this session, I was very happy. But then I thought it was about international organizations, and I thought to myself, my research agenda is not really on international organizations at this moment. But I wanted to address something that keep appearing in my emails and discussions and in different circles that I participate, and that involves the issue of the dispute settlement. And I was very happy to see that Michel's presentation left the door open for myself to speak about this. So the way I structured this presentation is I don't think I have a thesis at this point. But at the same time, I didn't want to reproduce what some scholars have been proposing, and I'm framing it as a research roadmap. So hypotheses that I thought about and that I've been testing more empirically to reflect on the role of the dispute settlement and seeing the dispute settlement as really part of this of the governance of the WTO, along with the functions that Michel has already explained. I was educated in a period where the WTO was booming, and I learned WTO law by cases, and Luisa took my class on WTO law, and she also learned cases. And then all of a sudden, this methodology of, or part of this very important part of the organization is no longer functioning. So the question then becomes now what happens? Because if the WTO dispute settlement body was something that was looked from other regimes as a regime that was really functional, right? What does it tell it in terms of dispute settlement at a larger scale? But I'm looking into what does it mean in terms of how we settle disputes, and if we can rethink ways of settling disputes in a less legalistic way. So my presentation then is structured from these premises, and I'll first address, before I address the crisis actually, I'll speak a little bit about this notion that was part of the narrative once the WTO was created, and how countries use this organization as a way to promote their public policies. There is this very interesting article that I read many years ago by one Brazilian diplomat called Celso de Tarso Pereira, and he manages to show how Brazil used the dispute settlement body to promote its part of its foreign policy. And many other countries did that. Michel also has this great article with Greg Schaefer on the trials of winning and the experience of Brazil in the WTO, and how the WTO really mobilized and created this epistemic community for trade lawyers in Brazil. So what happens now, right? We moved from this pre-WTO where decisions were resolved through like what is called a power-based approach. So the stronger countries, the more powerful countries will be able to promote their interests at the expense of smaller developing countries. And we moved to this rules-based system, right? As I'm going to show to you, I really think that the rules-based system, at least at the WTO, is really an exceptionalism, as an exception to the, when we think about trade governance and think about dispute settlement. So I could potentially claim that this is the rules-based system exceptionalism in the WTO. We recently, along with the elements that Michel has pointed out, there is this geopolitical and geoeconomic tension. We also have to name some countries in this geoeconomic tension. There is this increasing hegemony dispute between China and the United States. and that is also apparent in how we look and conceive and conceptualize about dispute settlement. So I'm going to speak about the elements that are out there in terms of what constitutes the crisis of the WTO dispute settlement. So some very technical elements. They should not be taken at face value, because when countries, make an argument, you also have to be more less, let's say, naive and see that there are other things that are underneath, but they're just not in the documents, right? And I'm going to think with you through alternatives. And when I consider alternatives, I want to look at what are the alternatives like coming from within the WTO. So what are the mechanisms that exist in this organization and maybe could be the face of this new WTO dispute settlement. But also part of my hypothesis was that maybe countries were looking somewhere else. So given that, potentially the WTO dispute settlement is no longer functioning, there are plenty of regional trade agreements, bilateral agreements, and maybe countries could use this avenue. So I tested, to the extent that I could for this presentation, empirically some of these claims. So, and then I'm just going to provide you with some takeaways from this early stage research. Okay, so in the crisis really struck the WTO in late 2019 when the U.S. consistently blocked the nomination of new appellate body judges. And in December, I think it was 21 December of 2019, that there was only one man standing, meaning that the organization on the dispute settlement could no longer operate because, according to the rules of the dispute settlement at WTO, you need at least 3 members. The reasons behind the U.S. Constant and repeatedly rejection of new appellate body members, they state in a document that the WTO or the appellate body was taking too long to decide cases, so they were not complying with the rules that provided that they need to be decided within 90 days, when a 19-day limit for appeals. They also criticized the fact that the appellate body members, once their terms had expired, they held over cases, so they were no longer competent or had no jurisdiction, but still they were working on cases. They were really concerned about the appellate body overreaching, meaning that they were deciding issues of domestic law, and there is this very specific issue on calculation of anti-dumping measures that the U.S. was really pissed at. And then also they were claiming that the WTO jurisprudence has no precedential value, but even with no precedential value, appellate body members were citing past cases as jurisprudence. And also they were saying that the appellate body was given advisory opinion, something that they could not. So this struck a crisis because, and this justified the block. And then you can move one more. Yeah. And then we have this bomb that basically you have the WTO dispute settlement, panels are still functioning, but the appellate body is no longer operative. So what happens? The one possibility is that countries, once you have the decision from the panel, one country or both of them can appeal, but this appeal, given that the appellate body is not functioning, it goes into the void, meaning that the case just stays there pending until we have an operative WTO dispute settlement body. But there are we can also see the crisis when we look at the empirical analysis from the 1995 until 2022. and this will show us that specifically from 2016, but starting in 2020, we see a decline in the numbers of or the utilization of the dispute settlement within the WTO, specifically in relation to the appeals procedure, right? So does that mean that countries are all of a sudden are happy with the way that panels decide cases, or does it mean something else, right? So if we look further, we'll see that there are options that have been thought through by participants within the WTO, and one is this creation of a provisional solution that is called the MPIA, which is the mechanism for provisional. I completely lost what MPIA stands for now, but it's basically it's a mechanism for arbitration, international arbitration, provisional, and it's provided in Article 25 of the Dispute Settlement Understanding, and basically tells that they found some members led by the European Union. They said, okay, let's keep it moving. So maybe not everyone's going to be on board. The U.S. definitely is not going to be on board. But if we agree on that, we can still solve those disputes at something that would substitute temporarily the appellate body, and still give some final, appellate body type solution to the case. So MPIA is out there, and MPIA has attracted a lot of participation, multi-party interim appeal arbitration arrangement. The elephant not in the room, of course, is the US, but you have all the major players are there, and reportedly the MPIA have been used with some success. I have some numbers here. So we have 2 awards already reached by the MPIA, 8 ongoing disputes under the MPIA, and 3 settled panel without going to the MPIA. So there is something is going there. But also another way that we can think about dispute settlement is thinking about dispute settlement in this non-legalistic way, or much more thinking about sites that are non-judicial, right? And I see that this is increasingly the case. Brazil adopts that, as we see, Michelle and myself in our research for bilateral economic relations. But increasingly we see those types of approaches also at the multilateral level. So there is this mechanism called the trade concerns. And I'll cite this. This is an now old article by 2 scholars, Andrew Lang and Joan Scott, and they say that these trade concerns, which are committees or bodies within committees in the WTO, and they are seen as this space of governance which has so far received insufficient attention from scholars and theoreticians of the WTO, and which is more significant than has so far been assumed. So among the functions of these trade concerns committees, they are traditionally operate as information exchange, but they also have as functions the idea or the function of monitoring the harmonization of activities of sister organizations. They are considered also sites for elaboration of open-ended norms laid down in the agreements. And they can, as such, also work in a way as almost like a mediation, where countries get together and they try to resolve their disputes through mostly negotiating a solution that is non-judicial, but still it can work. The downside of it is that traditionally the trade concerns has operated under the shadow of a functioning dispute settlement system. So now it's trade concerns almost by itself. So if we look at the data on trade concerns, we see that at the same time that the number of appeals in the context of the DSB went down, you see like that trade concerns really went up. So part of the answer could be that, you know, like countries are still using the WTO, still using the mechanisms of the WTO, but in this non-litigious or non-judicial way. And I think that we can work with that hypothesis. And finally, if we think about responses still within the WTO, over the past few years, there have been meetings conducted by now over 145 members of the WTO. It was led by someone named Marco Molina, who was a Guatemalan delegate that was fired from his position right after he issued the report. But he was very successful, as I can learn, in proposing a methodology of finding ways in which we could work through the crisis within, specifically with thinking about the DSP. And he calls it a solution-oriented, interest-based, and bottom-up approach. And surprisingly, or maybe not so much, it is a lot about good offices, conciliation, and mediation. So there is a strong emphasis on these non-judicial ways of solving disputes. So, and this is something that was brought by the members. It's almost like they recognize that, you know, the old system, the old rules-based system is no longer operating, and maybe, let's be frank, maybe it's not going to operate, not the same way that it used to. So let's, you know, empower these other mechanisms that already exist in the agreement, but let's give more color to it, and let's think about procedures for better good officers and conciliators and mediators. They still think about arbitration, the same arbitration that I was describing in the context of the MPIA. And they seem to tackle some of the problems that have been raised by the US and other countries. So the problem of this very long, time frames for resolving disputes, the issue of overreaching interpretation. So they propose like creation of a committee, an advisory committee on legal interpretations, because remember the WTO is, after all, or used to be a member-driven organization. But of course, they were not able to reach any agreement so far on the appeals, which is really the hard question. Okay, and then I move. I don't know how long I still have. Maybe 5 minutes. Okay, and then we move to these other solutions that are outside of the WTO, and that was my second hypothesis for this presentation. And I thought that, okay, maybe given the number of regional trade agreements that there are out there, and I know that today there is no one single WTO member who's not part of at least one regional trade agreement, and usually these regional trade agreements, they tend to have dispute settlement mechanisms. So my thinking was, you know, we're going to see a flood of claims in this regional dispute settlement mechanisms. But of course, two important things need to be kept in mind. The first one is that not every dispute that can be brought before the WTO can also be brought before a regional trade agreement. So there's a question of the nature of the dispute and also the parties involved, right? And I did this, exercise thinking through more like through Latin American lenses. So thinking about the main agreements, trade agreements within regional trade agreements in Latin America, or that involve Latin American countries. So here are my first findings. Okay, so one very important agreement that was negotiated still during Obama years in the U.S. was this agreement called the TPP, the Trans-Pacific Partnership. It now has the name of CPTPP after the U.S. left when Trump was elected. And it's a mega regional agreement, so it's quite important. It looks at the Pacific, and some countries in Latin America are part of it. Um, are there new rules we can debate, like what explains, like in terms of the political economy of the TPP? But the truth is that they have a dispute settlement mechanism, and it has been used at least once between Canada and I think it's New Zealand. But the interesting question is how different is it from traditional WTO dispute settlement when you have the same people that are, serve as or have served as appellate body members, a member in the WTO, which is the case of Jennifer Hillman, but also, just very experienced WTO persons like the Petros Mavroidis and Colleen Sword. So maybe there is an argument that there is some path dependency. You're doing like almost like WTO law, but outside of the WTO. So, and then I looked at some of the other agreements or other, sites of dispute settlement, trying to find any type of like correlation between a downfall of disputes within the WTO and maybe like an increase in the disputes of regional trade agreements. I was not able to, so my hypothesis was not confirmed in the case of CIECA, which is a very highly utilized system in Central America, but from mid-2019 to mid-23, although they have several cases ongoing, the correlation is just not there. And part of the reason could be for the reasons that I stated in the beginning, is that maybe the nature of the dispute could not fall under WTO or under CIECA. I looked at Mercosur. I once researched Mercosur, so I have Mercosur has a special spot in my heart. But after the retreaded tires case, talking to a lawyer at the Tribunal Permanente de Revisión, I was told that there are no disputes within Mercosur, and that it's decided much more in like this non-judicial approach. I looked also at bilateral agreements. So there's some activities taking place. So even thinking about the U.S. has several bilateral trade and investment agreements, but for the purpose trade agreements, and it is enforcing its trade agreements. I think about labor cases and even the USMCA. They're still using this old type of enforcement mechanism. But also I found, and then I rely on my research with Michelle here, that there is room also for this maybe increased room for non-judicial approaches to dispute settlement. And we think about China. China is Brazil's #1 now trading partner, and we don't have a trade agreement with China. We don't have investment agreement with China, but we do have this arrangements and particular institutional bodies that are created in this different types of agreements between Brazil and China, that we have some evidence that they are using these non-judicial approaches to resolving their disputes. So this leaves me with some preliminary conclusions, or maybe even questions for me to research further. One is that maybe even though I really like, because I learned it, and we usually like what we are familiar with, even for the wrong reasons sometimes, that the time, like this very like legalistic rules-based system that we saw in the WTO is something now of the past, and there was a very exceptional period in time when you think about trade disputes. And that we need to be open at the same time to thinking about dispute settlement, on reconceptualizing dispute settlement using and relying much more on non-judicial governance. And I think that's somehow resonates with the monitoring system that Michelle was describing. So maybe the WTO dispute settlement is going to be something much more like that. And finally, I was not able to prove my hypothesis that a WTO dispute settlement has or failed or dysfunctional WTO appellate body has translated into more regional trade disputes. So that's what I have for you today, and I'll look forward to engaging with you in questions and answers. Thank you so much.
Thank you so much, Fabio. This was extremely rich. I myself have a few questions, but I would love to hear from the audience first and foremost. So please, who has questions? Jan has a question. Maybe, okay, great. So maybe, can one of you help me with the mic? And yeah. Or Lucas.
Thank you both very much. That was very educational, informative, and all that. I have two questions actually, probably for both of you. The first is an international organizations type of question, as perhaps could be expected, and the second as well, maybe. The move towards the multi-party, whatever it's called, what was it again? Interim arrangement. Right. Has anyone ever considered the constitutionality of that in light of the WTO constitution? And if so, what is the outcome of that consideration? Because it strikes me as sort of a reform of the WTO without going through the regular, the regular procedures for reforming it. That's one thing. The other is that amidst all the talk, and I don't mean you guys now, but generally the geoeconomics, the Abu Dhabi thing, the one thing that seems to be left outside is the digital economy. Is that a correct impression? And if so, like I noticed the e-commerce moratorium that Michel discussed, but it seems to me that Jeff Bezos is being left to go home and get richer. And not only Bezos, but a bunch of other people in the same type of business, the Uber people and what have you. Is that a purposeful approach? Like the US is stepping on the brakes and say, you guys, we're not going to regulate anything. You figure it out and let the markets do what markets do best and may the rest of us perish. Does it work that way? I see you nodding enthusiastically, so maybe it does.
Let's collect a couple of more.
Well, I guess it's a bit hard to follow Professor Kleiber's questions. Well, this is a very technical subject, so I hope I can contribute something with my question. But well, what I would like to know, it's mainly a question for Professor Morosini. Is that if you think it would be essential for the WTO to regain its central role in trade economy, for it to reinstall its the functioning of its appeal organ, or if you believe that all these adaptations and these other forms that states have found to deal with the problem are enough. I mean, are we really losing too much without this appeal organ, or not?
It's also always hard to follow Sarah's question. But my question goes to Professor Michel Debadjing and concerns especially the second challenge you mentioned in your presentation. We have seen that many states have decided to implement in the last years some unilateral coercive measures, specifically quantitative trade restrictions and certain, one could say, violations or non-compliance with obligations of non-discrimination in trade law. And interestingly enough, many of these states decided not to justify these measures under the exceptions of GATT, whether the security exception or other exceptions in the previous articles. So I was wondering, what are the impacts of these decisions on the WTO system, specifically taking into account that this was a system framed in order to maybe expel the concept of countermeasures from trade law, and now we are seeing states responding to these limitations and implementing such measures? I would like to hear from you on that. Thank you.
Great. I think 3 for now is good. If you would both like to respond. Michele, would you like to start? And then Fabio? Okay, Fabio.
Okay, it's really hard to come after Jan, Sarah, and everyone. Those are great questions. Yes, there are on the MPIA, there are challenges to, I wouldn't call the constitutionality, but there are limitations for the MPIA. So there are some scholars are going to argue that you can apply most of the like the working procedures that you would use for the appellate body within the MPIA. But I think it's more sensible to recognize that this can only take place bilaterally, and so there is, as opposed to the WTO, the dispute settlement body, and the idea of single undertaking, you cannot pick and choose. The MPIA is it's almost like a plurilateral agreement. So countries that decide to join it, they recognize that they are opting in. So that's one difference. And so I think that they have party autonomy to do that. And secondly, the decision that applies to them does not affect other members. But so far we only have two cases that have been fully decided, and now it's a question of how to implement, and then the question is, do we follow the same monitoring rules for implementation that it would follow under the traditional or usual WTO? So there are some questions, but I think this is much more a move, and I see that it's been promoted by especially Europeans that we're happy with the court system, and they want to see it moving, and I think they were able to attract other participants who are also willing to follow the same path. But I think it is definitely something that's considered by these countries as something that's a transition to something else. I don't think maybe it will. Maybe the future is that you still have something as an MPIA. But it was the way I see in the discussions that I read is much more of like a discussion on like, okay, we have to solve this. The U.S. is not going to let go of this of its requirements, and if we have Trump again, it's going to be even worse. So on the digital economy, that is a great question. The reason I'm also tired today is because I stayed up until 12 in the morning last night because I was finishing up a policy brief on the digital economy and its impacts on Latin America. And the truth is that there are three main ways of regulating the digital economy. One is from like the US model. It's much more like, used to be much more tech friendly, but lately, last year, the US issued a new decision that is saying that we are concerned about the consumer and we are concerned about workers' rights too. So there is very recently, the U.S. has switched its position. We don't know yet whether it's purely discourse, because as you know, the tech companies in the U.S. are very powerful players, and they have been managing this agenda for many years. And on that topic, there's a very interesting article on the Project Syndicate yesterday from Stiglitz on how the U.S. has moved its position. Yeah, and then you have other models that are taking place at the European level, much more like privacy oriented, and then a third model, which is the Chinese, which is very much about cybersecurity. And the interesting part is that yes, the WTO is part of the process in terms of discussing digital trade. It started as e-commerce, but now it's one idea of a plurilateral. But I really see that the action is taking place outside of the WTO. So through this and how different countries or hubs are being able to capture and mobilize and proliferate and convince about its model. So that's like the dispute between different ways of regulating the digital economy, but outside of the WTO.
Great. Michele?
Yes, just two short remarks. One is about the digital economy, just keeping in what Fabio has already mentioned. I think that since the Clinton times, I think that the only countries that raised their hands since the beginning were Cuba and Venezuela that said, no, it's not okay to give this moratorium. But all the members, it worked like a silent consensus because they all laughed at going on, and for sure that was of the interest of the big players, such as the US, for sure, but Europe and Japan that were happy with us. Since China is there, they are not so happy as before. But then they started to think about that topic more outside of the WTO, and I think that there are two ways today, besides the multilateral moratorium, is just that countries are thinking about inward-looking policies, such as today Brazil is thinking how to tax Shine and other e-commerce big companies. And others are the sort of agreements that Fabio just mentioned, thinking about the RCEP and other more regional or friend-shoring systems that are thinking how to regulate that in where they have their digital value chains and to have to put some rules ahead, right? But even for Europe that decides to be like the rule-making organization or actor there, I don't see much coming from there for a multilateral thing. And it's really impressive. It's impressive. And if you keep the track at the WTO, Sara is not wrong, your point, because trade negotiations became such a technical thing. And they discussed it if it was service or good, and they couldn't get a point if it was a service or good and how they would regulate that, and they stopped. It's crazy, and the word is going on. Just to give you a picture of what's going on. So about the protectionism, and I think that there again, it's a way of giving us new glasses to look very closely of what's going on, because countries are invoking many types of excuses for those unilateral trade measures that have impact in the trade flows, as all the data that we've seen published in the last years. But there is a disguised protectionism there that is clear, especially for strategic sectors that were elected, and they are very, they can be the same for the big economies, but for countries such as Brazil, what are the strategic sectors for Brazil? Would that be agriculture? Okay, but all the countries are much more protectionist than we are. Are we thinking about minerals? It's not in our hands, the force for this sector. So then for sectors thinking about energy and food security, so countries are also invoking, enlarging this notion of security, and pandemic helped a lot on that. So they are mobilizing different notions of security, food security, energy security, health systems, that brings like non-economic concerns. And another non-economic concern would be the environment, in a way that we are protecting the environment, but so sometimes it's not really that. It could be other ways. And the WTO was a gatekeeper there in challenging if there would be other measures that should be taken instead of a more protectionist measure, but the organization has not been mobilized for that. All the countries are kind of waiting. And also there, I think that there is a violation of very complicated rules. It's clear that all countries are using their own tools for industrial policies, but no one is going for subsidies to the WTO or applying countervailing measures. It's so complicated technically. They don't have the tools for countervailing measures. We know the anti-dumping measures. But for countervailing, if you ask people in the Ministry of Industry, they say, we don't have any reference, we don't know how to map that. And so the econometrics of the thing is hard. That's why countries have been able to be very much innovative in the ways of invoking different sorts of protectionist measures and excuses for that.
Because I didn't respond to Sarah's question. But I was thinking about it, and I think Sarah's question is something like, should we want the old WTO system back, right? Ideally, I would love to, because I know how to operate it. But I don't think it's going to happen. So I think we need to learn how to navigate this new world of geopolitical and geoeconomics, and learning how to use this, less judicial sides of governance. I think Brazil traditionally does a good job there, but what I'm really concerned about is because I think that countries like Brazil can navigate the system, but I don't think that the majority of developing countries can. And I do think that the rules-based system, with the flaws that it had, it was in the end a safe harbor for poor developing countries, who, at least on paper, had the same importance as a developed country, and could have the same rights. I mean, with lots of quotation marks, but. Yeah, I think that's something to be seen, and I think it doesn't look good.
Lesser of two evils, perhaps. I would love to collect maybe one more question from the audience, if you have it. Yes.
Good afternoon, thank you. My name is Lucas. I am an alumnus here of the LLM. Actually, my question is something there past all the lectures of today, so it also goes to Professor Galindo and Professor Klabers, of course. But there seems to be a common trend on abandoning a little bit of the legalism in all of the lectures of today and going to the politicization, and it kind of follows as well this trend on abandoning multilateralism and going to bilateral agreements and maybe alternative dispute resolutions as a solution, right? And Professor Klabers mentioned about politicizing a little bit more the law studies of international organizations and understanding them as actors of political relations in general. So what are actually the effects of that to our research in terms of methods? Should we just incorporate more of a political science and international relations studies, or no? Because we've seen attempts of that regarding international organizations and international law in general. And is that in some way a symptom of what we are seeing now of it's getting hard for us to defend a little bit the space of international law in dealing with this political crisis and all the problems that we're seeing in the world? That's just a broad question. Thank you.
And off the back of that, I will abuse my chair privileges, and I have a question that's kind of to both of you as well. Because Fabio talked about it, and Michele has written something amazing that explains a lot of it in the past. What happens to the Brazilian specifically, but more generally, this epistemic community that was so involved in the system? So what happens to these lawyers? Because we know that the market was once created and it perpetuates itself. So everyone, when the Yugoslavia tribunal and the Rwanda tribunal closed, everyone migrated to the ICC, and they keep trying to open new courts to absorb these people, and the same thing happens everywhere because it's an issue of professional market. Fabio has already touched on this, so I was wondering if you could both maybe speak a little bit, not just the method part of what academics do, but maybe also what practitioners are doing when it comes to that. So yeah. Who wants to start? Michelle.
Thank you very much for that question. No, that's impressive. Like 2 years ago, I went to the Brazilian Institute on Trade and Antitrust Law. That are the guys that really, the lawyers that work on the trade community in Brazil, that has been very much empowered by the WTO system and all the domestic measures that have been taken under that system. And they were kind of looking and saying what we will do, and we don't have more cases before the WTO. That was their main aim, like to be at the WTO in the future and to train people to be there. So I think that in Brazil, still when thinking about even this whole idea of geoeconomic context, it's really pretty struggling to us. It's really like, what does that mean? If we think about the wars, okay, it's fine, but it's not as close as it is in Europe. We are now not the United States that have the military power, so we are far away from all those stuffs. We are not such a liberal economy that was very much dependent on trade. What we will think, what is important to us, what is strategic to us today? We don't have that clear in mind. We know that what's going on in the big game, but I think it's not clear what's our role as Brazil there. So I think that applies to the Brazilian trade community of lawyers and economists that are working on that. And what I see for the big trade law firms and consultancies abroad, it's clear. For example, if you see White & Case, the guys that were working on trade, they are working on screening. They have been trained, and they have trained all their lawyers on that. And they know how to deal with the new protectionist measures. They are keep closely following that. And there are new firms that have been developed to work with risk, the notion of risk. Let's measure risk. And so they're doing this sort of job. It's a new field of work. I don't know how that will have any spillover in Brazil on that sense, because I still think that in the geopolitical meaning and geopolitical economic perspective, we are still finding what are our goals or our main stuffs there. And wow, that's very great questions about the methodology. And I still think that, and today in the morning I was just talking to George about this, that I think that we have a repoliticization of the system, but I think that we still have many rules there. Rules have been mobilized. And we need to understand what are the new rules. And for international economic law, I think that we have the benefit that this field has an understanding that is not a field. Fabio and I, we've been working in a matrix of analysis that we think not only about international agreements, but also national regulation.
Published here.
Published here, yeah, that's true. In the UFMJ journal. In the national regulation, and even contracts and private standards, they are all part of international economic law field. So I think that we have to take a look of what is going on in these three levels, what are the sorts of innovation, what are the actors that have a role on this. Maybe are not the lawyers as they were in the past, maybe it's not the Ministry of Industry, but other ministries that have had a role on this. So I think it's, we should identify, but thinking more broadly about the main topic of the meeting today, I think that there is very important questions for the international system as a whole. What are the principles, what are the kind of goods that we are protecting, and how we will do that. What is the language? There are lawyers that are saying that we should move our language for a risk assessment idea, and law should be a tool to prevent risk. I think this is not enough, but I think that we should discuss as an international community. What is the role of international law today? What would be the role of the common goods that we have, such as organizations? Doesn't need to be international organizations as the standard ones, but what we want about our associations and connections, what we need to create and develop. I think that we are living a moment that we can bring these new ideas, because our way to interact and our problems are different from those that we had on the beginning of the 20th century, for sure.
Can I just add something? I think I just want to add something on Lucas'. I think like a shared anxiety, or like, what do I do with everything that I've learned, or why am I learning these rules if they seemingly do not function? But I think there is a word of hope. I don't know. I myself, I think I was educated in a very like positivistic way, and I learned, like WTO law and investment law, like looking at cases and what the cases say, and how different courts interpret treaties. But I think as an academic, and especially, I mean, you are, young academics. I think it's part of the process of being open to, different ways of thinking about problems. And I think it was brought this morning, I think, by Jan, when he was saying, like, you do not need to apply your law and economics to everything, and you can be open to other things. And I think there is something that is quite, that we need to keep in mind, regardless of the method that we use, is there are a lot of like fetishization of like different methods, right? So people talk about, okay, now I'm going to use, like hardcore empirical analysis to prove X point, or there's the turn to history in international law, right? And George is much more competent to argue that. But I know that there's people are disputing on how, for instance, you use history in law, right? Because it's almost like, okay, now you're historians. No, and I think that the argument that Anne Orford makes, that, in the end of the day, you are legal scholars, right? So you can you can learn from these other sciences, but those other sciences are not going to solve your legal problems, right? So I think we have to be open to these other methods and learn from them, but I think in the end of the day, the answer is within the law. That's where we operate and how we've been educated.
Brilliant. Love that Fabio brought a message of hope at the end. So thank you so much for being with us for this wonderful panel, yet another one. Lucas, when do people join us for the next session? Are we going straight in? In 20 minutes, so we're going to have a little break, and then you'll hear both Lucas and I talking about the International Law Commission, so do join us then.